Okay. Thank you everybody for joining us for our mitigation career exploration workshop. This is our last career exploration workshop of the spring semester. We really appreciate you all joining us. It's a really interesting subject with two very knowledgeable speakers. So we're starting with a presentation from Ariane Eigler, who who is a mitigation specialist for non-capital work. And then it will be passed on to Elizabeth Aguirre, who is a capital mitigation specialist. So everybody, please feel free to share questions in the chat, or even if you're comfortable to unmute yourself and ask a question, of course, at a point when the folks aren't speaking, and or any comments or thoughts. I'm sure that the speakers would love in any kind of engagement or thoughts that you have. But I will pass it off to them. I'm really excited about this one, and I'll be quiet and let them go.
Well, thanks so much for having us. I'll give you a little bit of background about myself, because I know folks are always interested in how you kind of came to work in this area of practice. I am from Texas originally, and got my MSW in New York, and stayed in New York working with immigrants and refugees. When I was in school, there was no talk of mitigation. I had never heard the word, no talk of social work in a legal context or forensic social work. And I worked with immigrants and refugees after graduate school for several years. I went and worked abroad. And when I came back from working abroad and needed a job, I sort of stumbled into a role at the Bronx Defenders, which is a big holistic public defender's office in New York. And they had started a new program. They had traditionally done criminal defense and immigration and civil and a bunch of stuff. And they had started a new program representing parents who had been charged with abuse and neglect in family court. And so I was sort of recruited to work there. And on day 2 of that job, knew that I had found my calling, and that this was really what I was meant to be doing, and why I wanted to be a social worker. And so I worked at the Bronx Defenders for many years, first in the family defense practice, and then I became a supervisor of both the criminal practice and the family defense practice. Decided to move back to Texas and started working at the Office of Capital and Forensic Writs, doing capital post-conviction work. After that, I worked at Texas Civil Rights Project for a while, and have now been at the Federal Public Defender's Office for the last 5 years. As you will see, Elizabeth and I work under the same umbrella. We're both part of the Federal Public Defender for the Western District of Texas, but I work in our trial unit across the district, and Elizabeth works in our capital habeas unit, which you'll hear a little bit more about down the line. So that is me. Today, I'm going to be talking a little bit about mitigation in a non-capital context. We do periodically get trial capital cases, but those are the exception. For the most part, we're doing non-capital work, which basically means any federal case that does not involve the death penalty. It can be a wide variety of charges to that. So I don't know who's in the room and how familiar you are with mitigation or not. I was going to do a little query, but it's not worth having folks turn on their cameras and all that just to see. But for folks who are not familiar, a little basics about mitigation. Mitigation in a criminal defense context means telling a person's life history, their story of who they are, where they came from, having the court, whether that be a judge, a jury, prosecutors, probation officers, whoever's involved in the system, see them as a human being, see them beyond the charges that brought them into the system. Many times that's all anyone knows about, all anyone talks about. And so being able to humanize that person in front of them, and for whom they have a lot of power. And mitigation doesn't have anything to do, doesn't need to have anything to do with what they're being charged with or what they've been convicted of or have pled to. It's not an explanation for what happened. It's just explaining who this person is and how they came to be where they are now. And trying to seek a little mercy in an otherwise oftentimes very unmerciful system. So, when you think about jobs in this area, they're not all called mitigation specialist. There are social work roles in criminal defense settings that are a little bit more broad. Mitigation's a large part of the work, but it's a broader role that involves other aspects. And you'll see this in a criminal context, in a family court context, like I mentioned before, in an immigration defense context, or civil, housing, or benefits, or any of that. You'll see social workers working in legal settings, bringing a very important perspective to this work. As you can imagine, all of these legal systems are very social history and social service heavy. So it's important to have an understanding of that. And that's not something that attorneys are taught to bring into their practice. So a lot of times when you hear mitigation, it's in the context of death penalty work and capital work, and that's critically important, as Elizabeth will talk about before. And like I mentioned, I've done capital work as well, and it's extremely important. But I did want to show, I like to show this picture to just show what a small percentage the death row population in this country is compared to the correctional population at large. It's a tiny sliver. And so non-capital work might not seem as glamorous sometimes, or as sexy, but it's, if you really want to have an impact on mass incarceration, this is where the work is, this is where the numbers are, this is where the cases are. So a little bit more about, what mitigation is. It's a fact-based process of humanizing an individual. And you're telling a story, right? It's an advocacy story, but it's storytelling to let the judge, the jury, the court system know who this person is. So going back through their family story, as many generations back as you need to, their mental health, their trauma, their substance abuse. I'm not going to read you everything on this slide, you can see obviously, but all of these are key elements. You don't want to just tell the sad parts of a person's story. You want to tell their inherent strengths, their capacity for redemption. It's really important that judges and juries realize that this is a person who has value and connection to other human beings, and that has the capacity for being part of their community in a productive and meaningful way in the future going forward. And so, where it makes a difference, a lot of times we hear about mitigation in a sentencing advocacy capacity. That's where it's used most heavily, is trying to impact the sentence that a person gets. But it's also incredibly important at all stages of a case, being able to advocate for somebody to get out on bond. You have to talk about their community connections and where they're going to live and what kind of supports they're going to have, and what kind of supports they're going to need and connect them with. And all of that work goes into, trying to get somebody out on bond so they're not just sitting in jail for years waiting for, a trial. They haven't been found guilty of anything. Same thing for trying to advocate for a particular plea, to get them a better plea, a better deal. Throughout trial as well, of course, even though the trial is about an alleged offense, it's really important to get the story of who the person is out there. The reentry, coming back into the community and connecting them with services, with programs they might need, employment, housing, all of that. We'll talk about it a little bit more down the line. And what I've been doing a lot of throughout this pandemic is compassionate release cases, being able to pitch to a judge why somebody deserves to be released from prison earlier than they would have otherwise been. And that can have a lot to do with how they've spent their time in prison, but also with their particular vulnerabilities, their health issues, their family issues, all of that. I want to go back just one slide. As you can see, why social workers are particularly suited to mitigation when you talk about all the aspects that we're focusing on in a person's life and in their community life. There are many mitigation specialists who are social workers. There are plenty who aren't. There are mitigation specialists with law degrees, with journalism backgrounds, with other backgrounds. it's more about the personality and the skill set than the degree, but social workers do bring an inherent value to this field, and that's something that's recognized by the people who are doing the hiring. They realize that. So some of the different places that non-capital mitigation is practiced, there's state level public defender's offices. So that's for people who are charged with, this is the majority of cases. People are charged in their county or in their state. So those are considered state level offenses. And that's, the Travis County court system. And there are public defender offices. For example, there's a brand new one here in Travis County that's just opening up. Some of these are government agencies, some of them are nonprofits. The Bronx Defenders, where I started out, was a nonprofit who had a contract with the city to represent indigent individuals in criminal court. There's also specialized public defender offices here in Travis County. We have a mental health and a juvenile one. Other places have other kinds of offices. The federal public defender offices, where I am, and they have them all over the country, and many more of them are hiring mitigation specialists these days. And then there are mitigation specialists who work freelance or independently. There's still many attorneys who represent people on criminal defense cases who are private attorneys that get assigned by the court. And there's definitely a need for social workers who can take on those cases when the court deems it necessary. So as far as federal cases, which is what I work on right now, that's people charged with any kind of federal offense, can range from immigration violations to kidnappings and bank robberies and guns and drugs and sexual offenses. So the federal statute with regard to these, to criminal sentencing lays out very clearly, this is the 3553 A factors, that the court in determining the sentence is required to consider not only the nature and circumstance of the offense, but just as equally important, the history and characteristics of the defendant. So in every case, we're required to lay that out for the court. But like we've talked about, social workers are uniquely situated to be able to bring a lot of that forward. Attorneys have a different skill set, and their focus is on the legal aspects of the case. So how we present the mitigation to the court, really depends on the situation and the story and the players and knowing your audience, like everything. Many times it's putting together a social history, which is a biopsychosocial assessment in other words, but it's more of a story. And it definitely has an advocacy bent to it. But laying out the story of who this person is, a lot of times that's folded into a sentencing memorandum, which is legal arguments around that story, telling the story and making legal arguments with regard to it. Helping shape a client's own words. It's a very stacked system. A lot of times it's hard for people to be able to tell their story themselves. And so helping them get it out, whether that be through letters that they put together or through, in federal court, they're always asked to do an allocution, so to speak in court on their day of sentencing. And a lot of times there's a lot of work goes into helping them prepare for that. It's a very loaded and nervous situation for folks. The same goes for family and friends, getting letters and pictures that help humanize who a person is, interviewing them and getting their stories. Family and friends can speak up in court as well. Working with experts to try to get more of a particular aspect of a story out, whether it be psychiatric, some other aspect of mental health, domestic violence, some other portion. And then one thing that's been, happening more and more these days is sentencing videos, trying to get creative with how we present a story, not just in writing, but being able to show somebody's life or their family or people who might not be able to come to court or might not be able to write letters, putting it into a video format. We'll talk about it a little bit more down the line. One major difference between capital and non-capital mitigation is in non-capital, we're thinking a lot about reentry. We're assuming that folks are going to be reentering their communities at some point in the hopefully not too distant future. And so we put together reentry plans many times for the court, being able to show what somebody would like to do or has in mind when they return to their community, or if they're able to get probation now. And so thinking about their connections to their communities and to programs and to all the rest of it is forward looking. And then I just wanted to sort of finish up with the story of one of our cases. I know sometimes it's helpful to have an example. Kiara was a client that we had a couple years back now. I wanted to use her example because actually our social work intern from UT played a huge role in this case. She really took the lead on the mitigation front in this case. Kiara was a young woman who had been charged with sex trafficking of a minor. She and her co-defendant, who was an older gentleman that she was in a relationship with, were charged with allegedly trafficking out a younger girl. And, you know, the charges sound terrible. Of course, they sound terrible on paper. You get to know Kiara and, you know, learn that she was trafficked herself when she was younger, that she was involved in a domestic violence relationship with her co-defendant, that he was really the one calling the shots here and making this happen. You learn a lot about her mental health history starting very young, her history in special education, her history with psychiatric treatment starting very young, becoming a mom at 15, her family relationships, and then, you know, her real strengths, the important role that she played within her family. And she was sort of the caretaker for her very large extended family. Kiara was able to get out on bond through some of our advocacy and stayed out on bond during our case. So she was working, she was supporting her family. They were able to move to a bigger house so that she, you know, largely through her income. She was under house arrest. She had an ankle monitor. So other than going to work, she wasn't able to go anywhere. And one of the things, I chose this picture because Kiara got a fish tank, and it was, you know, I think the thing that kept her grounded was taking care of her fish. When she would just sort of light up when talking about her fish. And so we really, you know, we're trying to think through how to present, you know, all that the judge knew about Kiara was that, you know, she had pled guilty to trafficking a minor. That sounds really terrible. How do we tell the rest of that story? How do we have the judge see it? One of the important things with Kiara was just developing that ongoing relationship and rapport. And that's where the social work intern really played a huge role because Kiara was on an ankle monitor. It was home visits. Our social work intern visited her every week and really developed that relationship. We worked with a psychologist to get an evaluation done of Kiara so we could have a better understanding of her mental health. Before we even went there, we gathered all of her records, her medical, mental health, school records, everything that was relevant. We also worked with a domestic violence and trafficking expert who was really able to point to Kiara's role as a victim herself in this whole situation. And our social work intern put together a reentry plan of services in the community that Kiara was going to engage in or was already engaging in. We got letters from family and friends. We helped Kiara do a letter of her own, which was really a hard process for her. And then finally, we decided to put together a sentencing video so you could see a day in her life, you know, which we had seen by visiting her at home and at her job and stuff. But that's something the judge was never going to get to see a perspective. And so videotaped her at work, on her commute, at home with her family, interviewing her family, with her fish. Again, that sounds so trite, but it's something that really humanizes a person who, you know, on paper just looks like a bad set of facts. and put it all together and presented that all to the court and to the judge. And it really did make a difference in the outcome for Kira, but I think the whole process was really empowering for her and her family as well. It was really meaningful when her family sat down to watch the sentencing video. I think it had a lot of value beyond just the sentencing outcome that she received in court. So I'm going to wrap things up here. So we have time for Elizabeth, but we're definitely open for questions at the end, and I'm happy to talk further. My contact info is in that first slide too, if anyone wants to be in touch down the road. Thanks so much.
All right, thank you, Ariane. Oh, can I answer that? Let's see. Can you all hear me? Can you? Ariane, can you hear me? Can you guys hear me? Okay.
Yes, we can hear.
Sorry. Okay, perfect. Thank you. So yeah, so Ariane and I thought it would be would work well for us to split up our presentation by her work being pre-trial and then talking about post-conviction mitigation work in death penalty cases. And just very quick with my background is I'm a graduate of UT School of Social Work, so I have my bachelor's and master's degrees from there. And I got my master's degree in 2000, so I've been practicing quite a bit. But like Ariane back then, there was no talk of mitigation. There was no talk of any kind of forensic social work. And I stumbled across it when I started working also at the Office of Capital and Forensic Writs, which is where Ariane and I first met. And we did post-conviction mitigation investigation. And that's when I realized I loved this work. So, but my background's been mostly doing healthcare, like medical social work, work for Child Protective Services. And so I fell into criminal defense, and this is just where my heart is. So with capital cases, when someone's sentenced to death in Texas, their case, that conviction is going to get automatically appealed in the state and federal courts. The unit I worked under, it's called the Capital Habeas Unit, CHU for short. And our office is appointed to represent folks that are we're appointed to represent people on death row in Texas who are now their appeal is in the federal court. So that's where the federal habeas starts. So we don't represent everyone in Texas. There's different CHUs around the country that have the death penalty. And in Texas, there's two CHU units, one in Dallas and one in Austin. And our office has just opened like 3 years ago. So we're still fairly new. But in federal habeas, our team is required to review all the work that's been done on the case, starting from the offense all the way through their trial and up to the point where we are receiving their case. This is just a very simplistic flow chart of where a capital case kind of goes. So we're here at trial. That'll be, in the county of the offense. And so then after they are sentenced to death, they get 2 automatic appeals, a direct appeal and the state habeas, and those occur in the state courts. And federal habeas, that's where I work. That's where the case falls in our lap. And like I said, this is a very simplistic view. Our goal is always to go back to try to get our client to get a new trial. So sometimes this, kind of goes back and forth from federal habeas to state habeas. And it's a lot of work, takes years to go through all this process. Next steps after federal habeas is either individual is granted clemency by the governor, or that individual is executed. So just a few facts about death row. This comes from the Death Penalty Information Center. And so across the country, as you can see, as far as how many inmates are on death row in Texas, ranks number 3 in the nation. California is first and Florida is second. So where there are 210 people on death row in Texas. And this is from the Texas TDCJ, Texas Department of Criminal Justice website that has a lot of statistics on Texas death row inmates on their website. And it shows, just to show the racial disparities for death row in Texas is there are, 44.8% of individuals on death row that are Black, 27.6% that are white, and then 27.6, and then 24.6 that are Hispanic. So there's a very big disparity there. And as far as executions in Texas, Texas leads the nation in executions. So there have been 570 executions in Texas over, I think it's been since the state initiated executions in Texas. So we're the highest at 570. And just to show you a contrast, the next highest is 112 from Oklahoma. So it's very significant. Texas is pretty up there on this. So with post-conviction, I showed this little drawing because it's like an uphill battle with what we're trying to do at this point in the case. It's extremely difficult to overturn a death sentence. It requires a lot of work, a lot of dedication from lots of different people. And our goal ultimately always to kind of go back to get our client a new trial. And so with the mitigation piece, what we're trying to do is create a new compelling narrative that humanizes our clients. So just like Ariane talked about earlier, it goes the same for us. The thing that's hard for us is during trial, the prosecution, is painting a pretty horrible negative view of our client, right? And bringing up every bad fact about our client's life and any prior involvement with, the law, and bringing, witnesses that testify and saying pretty horrible things. And then a lot of times, unfortunately, defense attorneys at trial don't do a very good job at presenting clients' mitigation evidence. They'll bring in witnesses that will say your client was a good person. Like that's a very common thing that we see, but don't really dig deep to try to talk about what it is that got your client where they are. So lots of times that's, trauma and things like that. So what we're trying to do is create a new narrative and then convince the court that had the jury heard this information, they would have returned with a different verdict. And I guess I didn't mention this earlier, in Texas, the capital murder punishments are either a death sentence or life without parole. Okay. So Ariane talked about life history investigations. Same applies to the work that we do. We are trying to get information about our clients from prenatal all the way through current imprisonment. And it's hard to get information from extended family. We have to do multi-generational life history investigations. So we have to do a lot of work in trying to gather some records and paint a nice full picture of our client's life. I just wanted to show my job right now and what it looks like. Because of the pandemic over the last year, we haven't been traveling or doing any field investigation, which is a big part of what I do. We've been closed, like our office, we've been teleworking for the last year and a couple months. So I've been doing a lot more of record review. And when I say extensive record review, it's like a lot of records. We're looking at all mental health records, medical records, school records, but we're really trying to create some sort of timeline, try to identify schools that our clients attended. Did they move around a lot? Getting records from there. We're trying to find any patterns of behavior for our client, but then also their family members. And we, a lot of you are probably familiar with having to get certain releases of information signed so that we're able to get records from, like get a HIPAA release or get a general release so we can get records from people. But there are also lots of places that require their own release. And it takes us time also to try to get family members to sign releases, which can be difficult because a lot of times they don't feel like their information could be helpful at all in our client's case because they're not the ones that committed a crime. They're not the ones that committed a murder. And why do you need my information? So, and we do, it's very helpful to get their records, but take some time to explain and convince them. And then, then I'm off to field investigation. So for like what it looks like for me, and that's different from Ariane's work, is that, we're like out knocking on doors. For those of you that have seen like documentaries on people going and, doing some post-conviction work, it really is literally going out and knocking on doors and trying to speak to people. Hopefully they'll talk to you as well. But as I'm reviewing records, I'm identifying people, and not just family members, but teachers, classmates, cellmates, anybody that may have been with our client in jail while they were preparing for going to trial. So I'm identifying these people, and I also investigate them. So I will do like social media searches, do criminal background checks on these folks, like trying to get as much information as I can, especially if they testified at the trial. What did they say? Did the trial team talk with them? And identify like places where maybe they said something that was kind of not, I guess, not a complete story, like where they maybe were testifying and the attorneys didn't fully allow them to elaborate. Like I'm trying to find that kind of information. And then I locate these individuals and then we travel to wherever they are. So just one kind of cool example of work that Ariane and I did was when we were working in the other post-conviction office, we traveled to the islands. So our client was born in St. Croix. He had family in St. Martin. He had brothers and family, like aunts and uncles there. But he was born in St. Croix. And so Ariane and I both traveled to the islands. That was really exciting. So Ariane went to St. Croix to go to his neighborhood, our client's neighborhood. Where was he born? Trying to get records from that hospital. So she was kind of on the ground there. And at the same time, I went to St. Martin and I was interviewing the family members that were there. And so that was like, no matter where they are is where we're going to try to find them. I traveled to different prisons around the country and the state to talk to different witnesses. And then I wrote this like showing up at schools just as an example. Sometimes I will show up to a school. I know maybe clients went to school there and maybe to see if a teacher still works there. Also, schools have old yearbooks. This is just kind of an aside for many, many years. So I've gone to schools and asked to speak to the librarian and see if I could see their yearbooks. And that way I can like identify other classmates, teachers, things like that. Because it's really important for us to find out what our client was like as a kid, especially, for example, if we're doing an investigation on intellectual disability, we want to get stories from the school. As social workers, we know that to get very sensitive information, we won't gather it all at once in the same first meeting. We have to do multiple in-person one-on-one interviews with individuals we're trying to elicit this information from. So our clients, are in prison and they're not allowed to call us. So our main they can't call us, we can call them. And the prison has some strict guidelines on legal calls. And the prison's been closed for over a year, but they just opened last month. So we haven't been able to see our clients, but it does require us going multiple times to speak with them. And just like any other, situation where we're working with clients, we're trying to gather information about trauma and any previous, substance use or anything like that. Does require, establishing rapport and having them feel comfortable to share, information with you. So it takes time. And this is just, I found this and I thought this was really good because we are trying to dig deeper and get more and more information, more anecdotal information about our client's story. Ariane talked a little bit about, how to present their mitigation that they find. And in our world, it's a little different. It's some similarities, but some differences. So we, can do genealogies on families, our clients' families. I do a lot of chronologies. One thing that we did recently and our intern helped us with is a trauma chronology for our client. And we basically just, as we were reviewing records, we were identifying what example of what trauma happened to our client during that time period. And we, categorized it as like, what kind of trauma it was: sexual abuse, domestic violence, racial trauma, just anything like that. And the reason and how that's helpful for us is we can sort like what's the source of all the records. It's helpful when our attorneys are drafting the pleading that we're going to file with the federal court, where we can provide that evidence and say, in this, in these, the attorneys, or we have been able to find these records and are able to support this trauma history, and previous attorneys weren't able to pull this together for whatever reason. Our successes are different. As Ariane, her work, oops, sorry, how do I go back? Successes look different. Just like I was saying, it's an uphill battle because it is hard to, it's very difficult for death sentences to get overturned. It's a long process. But some of the successes that I see are family connections, where it's oftentimes that our clients haven't had contact with their family in years. And that doesn't stop our work from happening. We still go out and speak to these family members and friends, and then come back and, talk to our clients. And occasionally there are some connections that are, they reconnect and they're able to communicate. And that's always a big success when we're able to help facilitate that. Other wins are if, let's say, we have a client who has an execution date, if we're able to get a stay of execution, that's huge success, obviously. But any win during their litigation is extremely helpful, and it helps other clients as well. If we have a win in court, other attorneys, other legal teams can use this outcome to help their cases when there's similar issues. And then, and then we have clemency. I mentioned it earlier. That's another win, and that's something the governor can grant. They can commute a sentence to life without parole, but they can only do that if it's recommended by the Texas Board of Pardons and Paroles, which this is actually really, really rare that the governor will do this, but that's something that we pursue. And then just lastly, I talk about like what fuels the fire for me. This work is really, really difficult and heavy, emotionally heavy, but it really helps to work with colleagues and a community that are dedicated to criminal social justice. We all, it helps, because that just makes us fight, and we have that good support. the arbitrariness of the death penalty is something that keeps me going, because it really is just something that's arbitrary, the way that the death penalty is applied to different people in the community, different counties. In Texas, crimes are like some, crimes, the death penalty is sought, and it's not right. And clients like Mark Solis, Mark is the guy on the left, and his brother is there on the right. And I worked on Mark's case when I was working at the state post-conviction office. He was sentenced to death in 2012 for a robbery murder of a woman named Nancy Weatherly out in a county outside of Fort Worth. He and a buddy of his were out on a meth spree that night. They went and kind of were just high, and were riding around in the country and found a house that seemed empty, but it wasn't. And so he was sentenced to death for that murder. We got his case in post-conviction, and the reason that Mark's story has always stayed with me is similar. Once you get to know the background, you realize this is, all these cards were stacked against him, but here he is now. And he was someone that grew up in the projects in Fort Worth. His mom puffed and drank during her pregnancy. He was diagnosed with FASD, and grew up in foster care, aged out of foster care. There was just a lot of challenges that he went through in his life. And so I really enjoyed working on his case. It was hard. And unfortunately, he was executed in 2019. And, his case went through the appeal process very quickly and quicker than normal. And I think it just had to do with, the issues in his case. They were a little complicated, but that's that. And then there are different agencies in town. Ariane's kind of talked about them a little bit, but some that do capital mitigation work are, the CHOOS. We host interns, MSW interns, and just kind of go back to the Office of Capital and Forensic Rights that we talked about. Texas Defender Service, they work on pretrial and post-conviction capital cases. And the Regional Public Defender Office also hosts, they have mitigation specialists. They do pretrial capital work. And then, like Ariane mentioned, there's people who do it, freelance. So, okay, that's all I have. I hope I didn't go over.
That's great. We are open for questions. And I also wanted to mention too, before we get into questions, for those of you who don't know, there is a course taught every fall a joint course between the School of Social Work and the law school at UT, a mitigation course, Mitigation Matters. So for anyone who will be a student in the fall and is interested and able to take that, I highly recommend it. A much more in-depth semester-long course in mitigation.
We have a couple of questions in the chat already, if you guys have seen it or not.
I saw one person asked about Kira's outcome. Yeah, she ended up getting a 5-year prison sentence, which we were asking for probation for her not to lose her job or lose custody of her son. Unfortunately, we didn't get that, but she was facing 20 years or more. So a 5-year sentence was a real success in that realm, but it was not what she or we wanted, of course, but she's doing okay. She's hanging in there. She's still serving her sentence. Okay, see what else is in the chat. We'd be happy to share the slides. Are there ways for undergrad social work students to get involved in the field? It's a great question. We don't generally take undergrad interns just because of the kinds of opportunities that are available, but I believe some of these other agencies, do you know, Elizabeth, if any of these other agencies take undergrad placements?
I don't think they do. I don't think they do, but I'm not 100%. But like Ariane, we host second year MSW students.
Oh, there you go. Bridget, who is our current intern right now at my office, said that the UT Law Clinics accept undergrads. I forgot about that. They do. There's the UT Criminal Defense Clinic. I know they take undergrads, and the Immigration Clinic at UT. So some of the law clinics take social work students as well, and they do take undergrads. So, and that's a great place to learn. How are sentencing videos different than clemency videos? You know, I have never worked on a clemency video. I imagine that there's a lot of similarities, but your audience is different, right? You know, with the sentencing video, you're really pitching it to a judge, and you're, you know, usually focusing on a specific theme. I think your audience and your purpose are different, what you're trying to accomplish. But, you know, I think each video, sentencing or clemency, is going to be really unique to that individual person and their story. You don't want them to seem like cookie cutter videos. We don't do sentencing videos all that often at the same time, because you don't want the judges to get tired of looking at them and tune them out. It's one of our constant challenges, right? Is how to make our clients' stories stand out in the unique way that they are. Unfortunately, the judges hear a lot of stories of, you know, people growing up in difficult circumstances, and you need to really make your client distinct. So yes, I think each video is going to take a different theme. I forgot to mention also, somebody pointed out, the Capital Punishment Clinic at UT also takes undergrads.
I was just going to mention on the clemency videos, we also haven't done clemency videos, but the audience is the Texas Board of Pardons and Parole. So that's who the audience would be there. Once you're in the clemency kind of campaign of the case, there's a lot of, you know, there's a lot of like outreach during that time, trying to get media involved. And doing clemency videos is something that they do as well. But it's very strategic. It's not like anyone, you're going to do it, you know, video on every case, because there's so many different factors involved, like the victims' families as well. You have to be kind of sensitive to that. It just really is dependent on the issues of the case.
I have a question. As states continue to abolish the death penalty, yay, do you think that a lot of mitigation is going to start targeting non-capital cases, or do you think that the field, I guess my question is, do you think that the field is going to become larger with possibilities as mitigation specialists might start focusing on other sentences, or will it become smaller because the death penalty is no longer in place?
That's a good question. I think the field is growing already. Obviously, capital punishment still exists, although it's shrinking. But there is more and more non-capital mitigation happening. And so I think the field will continue to grow no matter what happens with the death penalty, I believe. Maybe some of the people, the folks who are really experienced capital mitigation specialists, will move over to doing non-capital work. But I think the need will remain in one form or another.
Yeah, I was going to say, even, you know, that kind of, I guess another issue there is that a lot less, especially in Texas, it seems fewer and fewer district attorneys' offices are pursuing the death penalty. So you do see that, right? Sometimes you have, you know, a lot of cases going to trial and they have death penalty on the table. So there are people who are mitigation specialists who are working to try to prevent it from even going that far, so that they're looking at a plea possible for a life without parole plea, so that they're not going through trial. So I think that part, I think, is still going to be pre-trial. I think is capital mitigation investigation still probably going to be pretty busy. think some states are, busier than others. Are there any other questions?
I have a couple of questions, but I don't know if they were discussed. Sorry, my internet went out. But could you all speak to, I guess, consent, gaining consent to speak with families, as well as like your note taking, just in case, like for instance, if they're subpoenaed by the court, how do you guard those? And then a little bit, speak a little bit to, I think Elizabeth, you mentioned like, and I'm sure it is very tough work. Can you also speak to how you take care of yourself?
Ariane, do you want to answer the first part of that? Like
Gaining trust and consent. I think like everything else, like we all do with our clients, I think, we employ a lot of the same skills with family members, being authentic, active listening, following through on things we say that we're going to do, all of that, and building those relationships slowly. The kind of field knocking on door investigation that Elizabeth was talking about, you have to have kind of a tough skin. There are plenty of people that don't want to talk to you and will tell you that. A lot of times you end up, in the process of them telling you they don't want to talk to you, they will share 20 minutes worth of important stuff as they're telling you that they don't want to talk to you. So it ends up being an important interview in that process. So I think it's taking it where you can get it. Of course, we're always upfront about who we are on the consent front, that we're part of the defense team, that we represent this individual. So we're not lying about who we are, shading it. And there are folks that are going to have feelings about that. That's understandable. But knowing that going in and being prepared for, some conversations are easier than others. And then as far as note taking, our notes are protected as part of the attorney work product for the most part. I mean, I think there's certain questions if we were to testify in a case, whether that opens up certain notes or things like that. But for the most part, we are considered part of the defense team because we're working within public defender offices. So we're protected in the same way that attorney work product is protected. You want to get that last part, Elizabeth?
Yeah. Yeah, it's hard as far as like how I take care of myself, but I have a lot of friends, and so I have friends that have done this work and can understand it, because there are some people that don't understand why we would, why I would want to work and advocate for someone who's a convicted murderer. But I would say that the biggest stressor is potential, like if our clients potentially going to be getting an execution date soon, because that puts a lot of stress and pressure on the team, and of course our clients, who's something very difficult. But just staying connected with my colleagues and friends, and trying to exercise more. That's kind of what I do, and then taking time for myself and being okay with just being by myself and trying to do something, get my mind off of things. So it's tough work.
I have another question. When it comes to working on an interdisciplinary team, I'm sure that there can be maybe some struggles being one of the social workers or a mitigation specialist. I'm wondering if you can speak a little bit to that. And I'm also curious if you can speak to the different ethical obligations that you might have as being like a licensed social worker.
Yeah, the interdisciplinary part, can sometimes be a challenge, but more often than not, I think it's a real strength, bringing different perspectives into play. And most of the attorneys that I've worked with throughout my career have been very much, we're on an equal playing field. It's, I'm not working for the attorney, but they respect your professional background and expertise and what you bring to the case and to the table. So certainly we have different skill sets. When possible, I try to meet with clients with attorneys too, so that they can kind of see how I speak to clients, what I notice about clients during their conversations, what they're taking in, all of that kind of stuff, just sort of modeling a different way of interacting and communicating with clients. But, just remembering that they're bringing their important skill set and we're bringing ours, and hopefully we learn from each other throughout the process. As far as the sort of obligations, I think mandated reporting is the big one that people think of and ask about. A lot of that depends on where you're practicing. In Texas, actually, everyone is considered a mandated reporter, so attorneys are too. Obviously, that's what qualifies for mandated reporting is sort of a subjective consideration. So I think every office handles that differently and talks about it differently. The truth is that most of our clients are already under the scrutiny of so many different systems. It doesn't come up very often that there's something that needs to be reported because they're already in prison or in jail or being, surveilled by law enforcement or whatever. Things are usually out there already by the time cases come to us. So it doesn't come up all that often, mandated reporting. I will say that I started off doing this work in New York, where attorneys are not mandated reporters, and everything falls under attorney-client privilege, confidentiality, and social workers who practice in attorneys' offices there are also not considered mandated reporters for that purpose, because they're an agent of the attorney in that capacity. So when I did this work in New York, I was not a mandated reporter. And it was a very different way of practicing. Like I said, the challenges didn't come up very often. It's not like I was facing situations that, I felt like something needed to be reported and I couldn't. That almost never happened. It was just, it was amazingly freeing to be able to tell a client everything that you tell me is confidential and I will never share any of it. And it was amazing. I didn't think my clients were withholding things before, but it was amazing how much more came out just about their struggles to feed their kids or, have somebody to watch their kids while they went to work, things like that, that you would, you didn't really realize that they're kind of trained not to share so much of that. And so, yeah, it's a different way of practicing and something that you have to be comfortable with. But I found it came up more often when we would have a suicidal client and who was actively suicidal, who had a plan in deciding whether to call 911 or not, and you're breaking confidentiality there by calling 911. That actually came up much more often than the idea of CPS reporting. But yeah, understanding that you're working within a legal framework and a legal system.
We are at the end of our time. Any final questions? Throw them in the chat real fast. And other than that, guys, thank you so much for coming. As I said, this is our final event for our final career exploration event for the semester. We're going to be having job search workshops throughout May. If you guys are graduating, going to get into the job search, really recommend you look out for those in our social medias. Other than that, just really thank you so much for coming. To our speakers, Ariane and Elizabeth, you were incredible. Thank you so much for sharing your information. I feel like we've learned a lot. So thank you.
Oh, thank you all. And feel free to be in touch.